Hello, Meryl.
Thank you ever so much for agreeing to be interviewed. I'm doing sort of a series of interviews on people that make a difference. So I think in your role, you make a lot of difference to a lot of people. But let me just first introduce you. So you are the founder and managing director of Crossland Employment Solicitors.
That's absolutely right.
And you are also a practicing specialist employment lawyer. And also, I think it would be good to give you a plug because recently, as a company, you've launched the share ownership of your company, which is quite an unusual step, I would say, for businesses and for law firms as well. So I think that deserves a kudos on your part for doing that.
Thank you. We're one of only 5 employment law firms, legal firms to be employee-owned trusts. So yeah, I think the legal profession is taking a while to catch up with everybody else, but I'm sure that it's a way that a lot of firms will go in the future.
Okay, I think it's an excellent idea. So I've put together a couple of questions, well, more than a couple, 10. To ask you, and I think it's really sound advice for people who maybe don't use employment solicitors to sort of understand the vital role they play for companies. So I'll jump right in and sort of ask you, what role does an employment solicitor play for a company?
Well, I mean, essentially, we're there to sort of try and keep them on the straight and narrow, really, so far as their employees are concerned. And that starts right at the outset with complex company documentation. So I'm talking there about employment contracts. If they've got senior people where they need to put in restrictive covenants, perhaps some unusual clauses. I mean, obviously somebody of your caliber, Meryl, in terms of the general employment contracts and things, that's bread and butter to someone like you, but it's more the more senior people, all the types of businesses where they're very worried about employees running off with the crown jewels, running off with the secret formula to something that they sell. And then all the way through to employee relations work. And as you know, we work hand in hand often with the HR department or outsourced HR teams such as yourself. And we're often the sounding board. So we're the people that generally end up having to argue these things in employment tribunals. So we can say to a business, look, yeah, you could do it this way, that's the most risky, or you could do it this way, which is the easiest, or you could go down the middle, and in our experience, it'll probably work. And that's where we add value and also reinforce the knowledge of the HR team. Sometimes they don't have an HR team, and so they're coming to us directly and asking our advice. And we tend not to suck our teeth and say, "You've done what?" or quote legislation at them or anything like that. We try and resolve the issues, and then if it goes horribly wrong, we defend them in employment tribunal.
Excellent. Well, I mean, in my previous life, before I became a consultant, we worked many times before on things like that. So I know exactly what you get involved in.
Yes.
If we look at employment legislation in general, because it changes regularly, well, what do you think has been the most meaningful piece of employment legislation, say in the past, say 5 years?
Well, I mean, certainly, if you ask me what the most meaningful piece of legislation would be, I would say the Employment Rights Act 1996, which was a complete game changer for employers. Until then, if you wanted shot of someone, you paid them £12,000 and said goodbye. That was it. Then we had the Equality Act 2010. But in the last 5 years, I would say that the European Union Withdrawal Act, now that sounds a little bit sort of, gosh, what on earth is that? But that is the piece of legislation which said, OK, we're taking a point in time here. All case law that came from the European courts, because that certainly in discrimination and TUPE and things like that, working time, a lot of cases had to be refereed by the European courts. So that piece of legislation says that all of that case law basically still stands, and we must all be bound by it. until such time, of course, as the next case goes to the Supreme
Yes.
Court, which is the highest court in the land now, and they decide to overturn it. But that, I would say, is the most important piece of legislation.
Yeah, I would imagine that a lot of people think because we've left the EU now, they don't have to worry about sort of or the EU legislation that we've been bound by previously. But
Yeah,
we
absolutely.
Yeah.
Yeah, I mean, although the legislation doesn't, well, the legislation didn't have generally a direct impact on us, apart from the general data. I've even forgotten what it's called now, but data protection.
Yeah.
But everything else, we had to pass our own laws to put it into UK. Into UK law, but it's the case law, it's that interpretation that will still live with us for a long time.
Yeah.
And of course, people also forget that the European Convention on Human Rights is still alive and kicking. So employees can still go off there and claim that decisions made by employers impact their human rights. So Europe, we have not severed our ties.
Yes. Okay. So why do you think, I mean, I suppose it sounds pretty obvious, but why do you think it's important for a company to have robust employment policies and procedures in place?
Well, there's a very simple answer to that, which is that a tribunal will judge you based on how you have actually complied with your policies and procedures. So I guess if you were playing devil's advocate, you would say, well, don't have any, and then you won't be judged on them. But the trouble is that is your Bible. That is where an employee goes to know what standards are expected of them. And once you've put that, for instance, a disciplinary policy, you have said these things are indications of what we take really seriously, and they can differ from business to business. And if, for instance, I'll give you an example, a well-known supermarket a number of years ago dismissed an employee for putting on social media that although they were asked to be nice to their customers, frankly, she'd rather put a pickaxe through their heads. And they dismissed her for gross misconduct until the tribunal pointed out that actually saying inappropriate things about the customers was only deemed misconduct. And yeah, of course, you can't dismiss for the first offence of misconduct, generally speaking. It's only for gross misconduct that you can dismiss without notice. So as a result, it was found to be an unfair dismissal. So because of that, it's important to set out those robust procedures. What is it that is really important to this business? And then when you're coming to discipline somebody, please make sure you go back and read them and make sure that you are following it line by line. Because some of the businesses that we deal with, things like honesty and integrity are absolutely key because of the nature of the work that they do. And therefore, they are going to judge employees at a much, much higher standard than perhaps something different. So that's the importance.
Okay. Good to know. And hopefully some businesses will take note of that.
Absolutely.
If we talk about, I guess, what's sort of on the lips of a lot of people at the moment, which is things related to COVID. So I know there have been quite a few articles that have been written which have suggested that the furlough scheme has seen proportionately more women being furloughed than men, which could be, obviously discriminatory. Do you think there's any basis in that, or what? I mean, I guess the furlough scheme is like coming to an end now, so maybe it's not really any point. But I suppose based on the furlough, you might find the next action is that now that the furlough scheme is ending, there might be redundancies happening. And if you have just disproportionately more women being furloughed, do you think that companies could be running into a little bit of dangerous territory here?
I think certainly our experiences have not been that more women than men have been furloughed. I think it's probably a reflection of the kind of work that generally women will do. So, for instance, you will find more women who are working on the tills, say. Now, it is changing and it is becoming more balanced. And that's generally because they're often fitting in their work around the kids, and they're doing the shift so that they can pick the kids up and drop them off at school and things like that. So because of that, they have tended to be, it's a sweeping generalization, tended to be those frontline people, the people who are perhaps working in shops, and because of that, and apart from food shops, when all the shops were shut, of course, it was all of those people who were furloughed. Similarly, in the hospitality industry, I would say it's probably still true that there is a disproportionate number of women compared to men, and that is why it might look as if more women have been targeted than men. We haven't seen it. It was more to do with your job role rather than your gender that meant that you were furloughed. But also, bear in mind that the furlough rules allowed you to furlough members of your staff if, for instance, they were having to look after the kids because they were all sent from home. And in most cases, it was the women who had all of the delights of homeschooling, and things like that. So again, that's probably going to skew the figures a little bit.
Okay. All right. So we don't have to worry too much about it.
I don't think so. I can't promise that somebody won't bring a claim, but I will say publicly yet again, I absolutely take my hat off to HMRC for having got the furlough scheme up and running in the time that they did. And I can't really see employees wanting to bring a sex discrimination claim on the basis that they have been at home on 80% of their pay. Of course, there'll be the higher earners where £2,500 a month doesn't even touch the sides in terms of what they were getting previously. But given where it could have been, I think that I remain hopeful that most people are grateful to have had anything at all.
Yeah, I agree. Okay. I think this is sometimes as a topic, where people say, it's the principle of it, and I'm just refused to allow, to give in because it's my principle. So where do you lie when you've got a company that maybe, the employee, let's put it, has not behaved well, not behaved honorably, and now it looks like they're kind of holding you a bit to ransom, and they, going to take you to a tribunal, and it's going to cost you endless amounts of money to do it, but you just absolutely won't settle because it's the principle of the matter. Where do you lie in this? I mean, it's always sort of a kind of a tricky topic, but what advice would you give somebody in this situation?
Well, it's a situation we come across quite a lot, as you can probably imagine, as I'm sure you probably have as well. And you're absolutely right that, trenches are dug and they say this is a point of principle. And a lawyer is not doing their job unless they sit a company down and spell out in very, very clear terms how much those principles are going to cost them, what the upside and the downside is. Forget the actual cost of paying a lawyer to do the case. You've then got the disruption to the business. You've then got the fact that win or lose, the tribunal decision will be in the public domain. You've got the impact on the rest of the employees. We will spell all of that out to them. And we'll say, listen, happy to take your money if you want to push it all the way. But realistically, is that actually the best thing for everybody here? And I appreciate that there are some companies where actually they have a reputation for always settling matters, and that actually brings additional problems because you have the employees lining up to bring grievances whenever they want to leave. And so there is that fine balance, and sometimes a company does just have to put a stake in the ground and say, we're going to defend this come what may. But generally we'll try and encourage them to defend the cases that they're going to win, and that so that it really does send a message. But principles frankly count for nothing, really, in employment law terms. It is a much bigger picture.
Yeah. It's always interesting because I mean I've been on the other end of that too, as an HR professional in a company where an employee is just being really not honorable at all, and you really want to just go, what, to hell with it, I'm never going to pay him a red cent because of it. But Absolutely. Then you look at the grand scheme of it, you think, is that really worth it? Let's sort of move on from this and do what's the best for both company and the disruption it might cause your business.
Absolutely. And as you know, Meryl, it does cause a huge disruption if you are trying to litigate and trying to engage senior members of the team, saying, no, we need loads of hours of your time to do witness statements, to go through all the documentation, make sure that we've got everything in disclosure, and it's that bit that they forget about. We try as much as possible to explain in very clear terms what defending a claim is going to mean to them.
Yeah. What do you think is one of the common pitfalls that companies make about employment relations matters? Is there a common pitfall?
I would say that the most common pitfall is not talking to the employees properly, not engaging with them, being too quick to sort of write fairly legalistic letters to them rather than actually sitting down or going on a Zoom or picking the phone up to them and having a chat. We always say the more you talk to an employee, the less of a problem that you're going to have. So that, I would say, that's probably the number one mistake. The second most common mistake is a misunderstanding about being employed for 2 years. So a lot of companies think, oh, well, we're absolutely fine until a person has been employed for 2 years. So if I had £1 for every call that I have had directly from companies, not from HR professionals, obviously, saying, right, well, their 2 years is up tomorrow, so we're thinking about getting rid of them today because they think they can't bring a claim for unfair dismissal. So two things to remember. The first is that there are 32 exceptions to the 2-year rule. And the second is that when calculating whether a person has been employed for long enough to bring an unfair dismissal claim, you add on their statutory notice. That means that if you are looking to dismiss them, you have to have done so at least a week, and we always say 2 weeks before their 2-year anniversary. So that is probably the biggest pitfall and mistake that companies make.
Yeah, well, I know a former colleague of mine, I think a company did exactly that. You know, they sort of thought, oh, you know, she's within her 2-year period, and called her in and said, you know, sorry, you have to go now. But actually they'd miscalculated, and she was within her 2-year period. So
absolutely.
I think they were having to shell out the money, I think. What do you think companies should be doing to educate managers? Because obviously when it comes to things like employment relations matters, I mean, it's the manager on the ground that's managing those people that quite often are the ones on the front line that maybe are making the mistakes. So what should they be doing, and what sort of do they have a responsibility to make sure that their managers and supervisors are educated?
I think the starting point is that actually in the UK, we make that traditional mistake. When somebody's really good at their job, what do? We promote them to become a manager, and they go from being a really brilliant engineer or something like that, and we put them into a management role, and they are clueless, and through no fault of their own, because nobody has ever explained to them what you should be doing as a manager. So I would urge any company who is listening to this, please have some kind of management program. It doesn't need to be anything fancy. Pick your best managers and make them mentors for the junior people coming through, because otherwise what happens is you just perpetuate the same mistakes, and poor managers breed poor managers. The other thing companies need to remember is this, is that if you have given instruction and guidance and training to managers on how to avoid discrimination in the workplace, then you raise what is called the statutory defence. And what that is that when an employee comes to you and says, Fred has discriminated against me and he's harassed me and he's done this and he's done that, you as a business can say, oh, well, you need to take that up with Fred directly and bring a claim against him if you want. It's nothing to do with us, because we have done all we reasonably can to prevent Fred from discriminating against, being discriminated against. So because of that, I'm really surprised that more companies don't invest in, and it doesn't cost any money, to be honest. I mean, you can do free online training and keep a record of who has what training. So I think that is really key as well. And also, I mean, one of the things, and this is a plug for us, but it's just a practical point, is one of the things that we have found hugely successful in business is just giving managers a basic overview of employment law as it applies to them. They don't need to know, Section 1 of the Employment Rights Act, and what they need to know is, what basic rights do employees have in the workplace? What do you need to watch out for? What do you need to do in terms of fairness and talking to people, and how that can get you in trouble if you don't know it. And it is astonishing. And I do remember years ago, Meryl, you actually saying to me, I don't know what you've done to all our managers, but I've had a queue of them coming into my office wanting to engage with me for the first time in ages. And so it's empowering them to have a little bit of knowledge, but equally to know when to come to you, because it just steps outside their comfort zone, in the same way as you as a expert HR professional know when you are outside your comfort zone and you think, oh, actually, I better just pick the phone up to the lawyer, just make sure I'm not going mad here. So it is empowering that whole chain, really. And it works well in business.
Yeah, I think it's a powerful tool. And I think it also creates a lot of stability in an organization as well, when managers in different departments are treating people in the same manner.
Absolutely.
So if they all sort of have been provided an overview of sort of the right way to do things, then regardless of which managers and which department, their staff are going to be treated in the same way. So it creates a lot of stability, I think, for a company as a whole.
Yeah. I completely agree. Yes.
So now, obviously, you're a lawyer, so you have to be confidential, so you can't, give out too many secrets. But, can you relay a case where, because often in employment law, it can be really not particularly fabulous to, have to defend cases. Has there ever been a case that you've worked on that is really at the end of it, you felt, gee, I've really done something fabulous? So that's really kind of made you feel warm and fuzzy at the end of it?
I think so. I mean, although we primarily act for companies these days, we still do a bit of employee work, and certainly I used to do more in my youth. And I remember this was before we started acting for one of the Formula One teams, so I think I sort of cut my teeth. But I acted for an employee against one of the big Formula One teams, who'd been treated really terribly, and so we took on the might of this Formula One team. And they brought in all of their big guns and their aerodynamic specialists and things like that, who obviously sort of looked at me and thought, "Oh, you're a girl. You obviously don't know what you're talking about," but didn't realise that actually what we were talking about was aerodynamics. And I had a private pilot's license, so I sort of did really understand what he was talking about and was able to catch him out. And at the end of it, we won, and my client got the maximum amount of compensation. And I remember he rang his dad from the car in tears, and it was just, and the father was in tears, and he was on the phone to me, and I just thought, I've done good today. I've taken on the might of these people, and we knew that we were right and they were wrong, and it felt good.
Yeah, I can imagine. It's nice to be able to give yourself those mental pats on the back every now and then, isn't it?
Yeah.
So if we talk about hybrid working now, do you think that there will be any more formal change in employment law around that, do you think? Or do you think we're still sort of in the trial phase at the moment, and we're going to cut our teeth, so to speak, on what's actually happening and wait and see if anything comes out of it, from an HSE maybe claim, or who knows what might come of it. Do you think there will be any changes?
Well, there's some suggestion that the default position is going to be that all employees are entitled to flexible working, and that employers can then sort of add to that if needs be. And I'm sure that probably will come about. I mean, the last 18 months have shown us anything. It's like, employees are not sitting on their sofa eating popcorn in their boxer shorts. Obviously, they're a man. binge watching sort of Game of Thrones. So we know that it can work. I don't think that it works for every employee. And in fact, I've spoken to a number of employees recently who've said, actually, I want to go back to the office because I want to have that differential between work and home. Equally, for employers might say, yes, we've made it work, but to be perfectly honest, actually, it works better when we're all together. And you look at businesses such as the legal profession, where actually the only way that you learn is from listening to other people talking and learning from the answers that they give. So although it has worked, you can see businesses saying it hasn't been perfect. But I do think that I don't think that legislation is necessarily the way. Employees will vote with their feet. The one thing that we do know is that actually we've got a real skill shortage. And so firms that are not prepared to offer some kind of flexibility will find that they haven't got any employees, and they'll go to the firms that do. So, I think the government will probably put something in. I mean, it's a little bit like the flexible working rules at the moment. Yeah, yes, anybody can ask for flexible working, but the employer can easily say no. So I think they'll pander to the populace in terms of implementing something, but it will still be with the same get outs. So
okay. It is a question actually that I didn't actually put on my list to ask you originally, but it is so prevalent right now, which is the whole topic of no jab, no job. And I know you've given quite a series of various different interviews on local radio, and you've done podcasts on it and so on. So I know you have a very sort of balanced view of it, but it might be worthwhile just if you might just give me a little synopsis of your view on it. Just for people who might not have been able to catch you in the past on what your view is on this.
Yeah, well, it's very interesting actually, because a little bit like the whole lockdown and being guided by the science, my view is starting to change more and more now as the science and the various studies come out. And so, for instance, today, we have had a report that after a massive study has showed that those who are vaccinated are 50% less likely to transmit the virus. Now, I think that that's a bit of a game changer, really, not least because employers have have an obligation under the health and safety legislation to keep their businesses safe and to keep their employees safe and people visiting them. And we have already seen legislation which has made it the law to for anybody working in care homes and anybody visiting them to be vaccinated. The NHS have always had rules about being vaccinated, and now I think every business is going to have to look and make a decision. It's not going to be a one size fits all here, but they're going to have to look at the kind of work that they do, what they do if an employee says I'm not going to have a vaccination, and whether that is going to actually represent too much of a risk. And that there are two risks to the business. The first is that they will come in, they're 50% more likely to be carrying it and give it to people who may themselves not get ill because they've had their vaccinations, but they might take it home to loved ones who are older and frailer or have medical conditions, so they haven't been able to be vaccinated. But equally, there is a business threat here, because as of the 17th of August, if you have had both vaccinations, then you do not have to self-isolate if you're contacted by Test and Trace. And so businesses may take the view, well, for business continuity, I can't have the risk that somebody's going to be constantly contacted and is going to have to self-isolate, particularly if they can't work from home. So businesses are going to have to look at that and consider the reasons why employees, the potential claims that they might have. So they might be a pregnant woman who, for understandable reasons, doesn't want something relatively new put into their body if they're pregnant. They might have a medical condition which might put them into the disability discrimination. Age has probably gone by the wayside now because everybody can be vaccinated, but we have philosophical beliefs as well. They might say, I fundamentally believe that I should not have to be forced to put a vaccine, and that will be covered under the Equality Act and also under the European Convention of Human Rights. And in those circumstances, for discrimination and convention rights, a business is going to have to be able to objectively justify their decision. And that is balancing the rights of the employee against what legitimate aim are they trying to achieve? Keeping everybody safe. Have they done it in a proportionate way? Could they do it a different way? Say to people who aren't vaccinated, you'll have to work from home. The fear for businesses is that if they say that, then everybody who wants to continue working from home is going to say, well, we're not going to get jabbed then. Even if they have been jabbed, they might say that they haven't been. So I think it is going to become easier and easier to objectively justify it as the science comes through. And as people realise that they can't go to nightclubs, they can't travel unless they've been vaccinated, I think it'll be less and less of an issue.
Yeah. Well, I suppose time will tell, won't it? The next year I think is going to be quite telling. I was thinking about it as well, because if you have a job that requires, okay, at the moment nobody's doing much travel, but hopefully that will change. And if you have a job that requires you to get on a plane and fly all over the world, and you haven't been vaccinated, which means you have to quarantine or you can't fly or whatever, then presumably you wouldn't be able to do your job. So a company would seriously have to consider that in the light of all of that, which I'm sure those kind of things will soon start popping up. Those will be challenges for sure. Yeah, definitely. It's interesting times.
Yeah.
So my final question to you, Bev, is, you've been in this field for a very long time, and is there anything that still makes your eyebrows raise, or is it like, I've seen it, done it, got the T-shirt? Is there anything that surprises you?
Meryl, I can't tell you. We are surprised practically every day as a team. Really? Certainly every week. I mean, we catch up at the moment. We're still mostly working remotely. We catch up 3 times a week, and one of us will say, "You're never going to guess." And actually, we're seeing more and more of it, particularly during lockdown, particularly when people are working at home, because actually, far from employees being, you would like to think, fairly grateful for a job and the flexibility and understanding of their employers, are actually going completely the other way and behaving really very, very badly. Not all of them, but certainly more than they ever used to. And I think that that's reflected elsewhere in society. I don't know about you, but I mean, I dread going out on the roads at the moment because everybody's driving like lunatics, much too fast. Everybody just seems quite angry, and that is filtering down into into the kind of advice that we're having to give. So we have an understanding in our office, which is, every day is a school day.
Interesting. Well, thank you, Bev. That's been really great. I'm really grateful for your time, and
pleasure.
I'm sure that many people, if they listen to this interview, will learn a few things from the various different bits of advice you've given. So I really appreciate your time.
Thank you for asking me.